Good morning, friends. Namaskar, Sat Sri Akal. This is my 279th video, and this video will cover a very major question that some people are under an impression that since they are holding documents of lease in perpetuity of 1899 and 1912, so their properties or their bungalows cannot be resumed. So it is a clear case of discrimination after this judgment. Please note it. 1986 AIR Supreme Court 872. This was a case discussed under PP Act. It is a common ground that the perpetual lease was a government grant governed by the Crown Grant Act 1895, now known as the Government Grant Act. The act is an explanatory or declaratory act. Doubts have having risen as to the extent and the operation of the Transfer of Properties Act 1882, and so as to the powers of the government to impose limitation and restrictions upon grants under other transfer of lands made by it or under its authority. The act was passed to remove such doubt, as is clear from the long title and the preamble. The act contains two sections and provides by section 2 for the exclusion of the Transfer of Properties Act 1882 and by section 3 for the exclusion of any rule of law, statute, or enactment of the legislature. To the contrary, section 2 and 3 reads follows. Now, what does Transfer of Properties Act 1882? Not to apply to government grants. This is section 2 speaking. Nothing in the Transfer of Properties Act 1882 contained shall apply or be deemed ever to have applied to any grant or other transfer of land or of any interest thereon, heretofore made or hereafter to be made by or on behalf of the government, to or in favor of any person whomsoever, but every such grant and transfer shall be construed and take effect as if the said act has not been passed. Section 3. Government grants to take effect according to their tenure. All provisions, restrictions, conditions, and limitations over contained in any such grant or transfer as aforesaid shall be valid and take effect according to their tenure. Any rule of law, statute, or enactment of the legislature to the contrary notwithstanding. So now these two sections are very decorative, and most of our judgments, please, friends, listen to me carefully. We have lost on these two very sections of the Grant Act. Now, this act is after the TPS Act 1882. So we need to understand how do we counter this. Now, why did the Britishers wrote old grant in our GLR? Is for this very reason. So this goes to prove that when we are a grant, then TPA Act is not applicable. Then why did we have TPA Act briefed in various laws? Since 1864 till 1924 and even in the present Act 2006, Section 287 registration of sales. So my earlier videos are an explanation to all this. So please understand, it clearly says even if a lease is in perpetuity. So all people who are sitting on perpetual leases, please wake up. When your cases for resumptions will go, you will keep harping on perpetuity, and this is the judgment which will kill you. And these are the facts which kill everybody. The minute we come down and say we are a grant by the British government, we have to say we are an old grant. We were a revenue free grant. recognized by the Britishers under the Lakhe Raj grants or the Bashahi grants or the non-Bashahi grants. Had we been a grant under Governor General order, we could not have been a grant or an old grant. Suffix, we should have been a new grant. Where is it written? Read Baden Powell. In my coming days, I'll be harping my book, which is on land settlements, volume 1, 2, 3, by Sir Baden Powell. So, this will clear the doubts and my answers to people sitting across. Pleading is very important. And I'm again and again saying, you will not win if your pleadings are not there. So please don't go by the fact that no, Mr. Das, the pleading has to be very small. Pleadings will run into more than 1,000 pages or a 500-page plead plaint because you have to plead everything. Only then the court will lead an evidence or an issue and a relief will come forward. So wake up. Thank you. Good day.